Let's move on. Alexandra next, I think.
Okay, so good afternoon, audience, everyone. Today I'm going to talk about the data privacy risks of working remotely as a lawyer. And basically what I'm going to do is a bit challenging your perception of your daily routine, because basically by remote work, I'm going to mean any kind of working activities that you encounter outside your safe and preset work environment in the office, when everything is taken care of by your IT department or by your data protection officer. And in any moment when, for example, you have to work on the weekends at home, or you're working when you're commuting, or just sending your corporate email during the conference because you feel you have the rush to do so, this will all fall under the remote work concept, because in this way you're most probably working from your own device and you need to count your risk yourself. So I'm going to talk about some regulatory risks. So I will first of all give you the overview of how actually our data privacy risks are regulated and what we are expected to do as lawyers or any other professionals of our own field. Then I'm going to move on to the data privacy risk matrix, which means that I have created some kind of small table which will allow you to evaluate your own risks and be able to kind of challenge yourself and rethink what you're going to do on your daily basis, especially when the new data protection regulations enters into force. And finally, I will reflect a bit on how you can actually boost your own knowledge in this field, so to be able to meet your expectations, the whole public and the legal bodies kind of put on you as a lawyer who processes personal information. So that's the picture of the work environment you most probably likely to encounter if you work outside the office. This most probably will include working on your own computer, because maybe your computer, which was provided by your employer, doesn't work outside the corporate network, or you feel like being more comfortable to work on your own computer. You may be tempted to print some documents, or you may be tempted to use WhatsApp or Skype to communicate with your colleagues or some of your clients to make your communication more mobile, or you may use some USB flash drives so that to transfer your data really fast. And actually, all this daily routine puts a lot of data privacy risks that you most probably still not aware of. And that's what I'm going to talk about. So, first of all comes a regulatory environment. Of course, it's not possible to cover all the expectations and all the standards we have, but basically we need to be aware of hard law and soft law issues we are going to encounter. And when we are talking about the European jurisdictions, everyone is quite aware about the upcoming changes and the new data protection regulation, which will bring really raised standards. And on the basis of this, the national laws will change. It will basically happen quite soon in Finland, because it's still like the process is under kind of like reconstruction. Swedish national laws already coming into force quite soon. And then as lawyers or someone working in the legal field or working quite much with the clients, we still have the pressure of our own professional communities. For example, local bar regulations, because in this way, data privacy is also a question about morals and ethics. And finally, we have our employer, with whom you most likely have signed the data privacy documents or may have signed the remote work policy. And that's how it's going to be a quite big burden, which is going to increase. And then to make it a bit more kind of illustrative, it's about WhatsApp, a kind of one of the examples of you working remotely. So it's most likely that you use WhatsApp. Who has read the privacy policy of WhatsApp? Yeah, So that's not really a lot of people, and if we think about not the legal community, it's actually less. And there has been a research which has shown that for you to read the privacy policies of all the web applications, all the services you use, you need to take 1 month out of your work and just sit and read it the whole day. And that's the question, that we cannot read it all, but we can be aware of some risks and kind of instigate our legal intuition. So in this case, we have some personal data that we are going to send by sending the WhatsApp message. And then I will show you like some concepts of the new data protection regulation. So first of all, that's the consent, and it means like if you have a new client, then the new client has consented to be for you to process this data. But of course, you cannot reveal all your corporate communication system to the client. But still, your client kind of expects that you will not transfer the data to third parties or transfer it outside the European Union. Then there's also the right to access, because your client wants to know how you use this data, and most probably he's not expecting you that you process this data, for example, to discuss such an interesting case with your colleague from this firm or other law firm. And then we have a really interesting idea about the breach notification, which means that under the new data protection regulation, you actually have to be able to act really fast in 72 hours. And if you read the WhatsApp privacy policy, it actually implies that you actually need to notify also the WhatsApp. And then it also comes to the transfer of personal data. For example, with the WhatsApp case, we can see that data, you don't send the messages to WhatsApp. But what you send to the WhatsApp are the kind of your address book, when you may put the name of the person, you may put some details like he's your client, and you may put his mobile phone number. And of course, it already makes it possible to identify your possible client. And then it's about the right to be forgotten, because in this case, the person, your client may ask you to erase the data. But when the WhatsApp messages are scattered around the cache of all your colleagues, then it's quite difficult to do. And some people may just delete the WhatsApp application, but it doesn't mean actually deleting the messages. And here you need some technological knowledge. And finally, when we're talking about like data book and WhatsApp, it's actually stored outside the European Union, and here we encounter another problem. And when we come next, this is how I have like built some overview, really short overview of risks. And basically, this data privacy risk matrix covers technological and physical risks. The physical risks may include the situation when you print something from your own printer or from your co-working place printer, and you just basically forget the copy, or someone else prints some really personal, vulnerable information on the other side of this page to make kind of like the green office style, so it's like you don't waste the paper. And we have also the problematic systems of working in secure device and networks. You're kind of not expected to know how VPN works like, but you're kind of expected to know what risks you may encounter. And as you can see, for example, with cloud storage or WhatsApp, you cannot easily influence your colleagues to change their mindset. But when it comes to physical copies, and be aware about viruses and the risks the Wi-Fi works, it lies inside your individual field, the field that you can change on your own. And because of this, it kind of make all this data privacy landscape change, makes you rethink where you work and who your stakeholders are. Basically, you have this like circled lawyer who are yourself, but you still work with a team of colleagues inside your law firm and some other law firm who may be, for example, dealing with your assignments. And then you work with the technology. And data privacy kind of requires us to understand the underlying concepts. The remote work policy may kind of ask you kindly, don't print something outside your corporate printer. But you need to know why you don't need to print this. Because Wi-Fi connection is vulnerable, because you may lose physical copies, and so on. When you just read something without understanding this, it kind of makes you easier to break the rule when you feel you're hurried or you feel like you really need to print this document. And then comes the human factor. It's about knowing your customer, but not knowing your customer, but also knowing how your colleagues may act. And on the basis of this, I have come to some conclusions, which basically means like you need to treat data privacy as a personal hygiene. And in this case, imagine like you're a doctor. So it's not only about your own security, but about the expectation the society puts on you. And it's about like, some people still think it's about over-panicking, but then there's so many dangers, and someone may use your data privacy collected information as a currency, as a way to raid the company or destroy your personal reputation. Then it's about knowing your stakeholders and being able to influence the way how you communicate with them and be in the better bargaining power. And finally, it's about knowing what underlies the legislative prohibitions, knowing the technology and having some idea how you can develop this technological intuition. So that were some of my personal advice. I would welcome your questions, offers, cooperation, anything. So thank you for your attention.
Thank you. The general data protection regulation is surely a very timely topic, and currently many companies are struggling to be compliant with the GDPR, and especially because the GDPR requires that the controllers of personal data must be able to demonstrate the compliance. So what do you think, given those risks and issues that you just mentioned, how can a law firm demonstrate compliance with the requirements of GDPR?
Yeah, thank you for your question, and it's kind of really topical question now, because I believe with like old data protection regulations, there were not so many technological expectations imposed on, such as breach notification, and at this moment, like at previous moments, the firms could somehow get by, for example, only drafting the privacy policy and publishing it on its website, and making it look like a static document, or making you agree to like cookie consent, whatever. But I think the new expectation that data protection regulations puts on us is something about more dynamic context and about understanding the technology. Of course, it still will be about some kind of really nominal things, like being able to update your documents. But then it also comes about the technological training, because this is one thing, like when you have a compliance officer or data protection officer who makes a remote work policy and who kind of like make people sign this. But that's another thing of how the employees may, for example, balance the value of really, for example, providing the services really soon. For example, like the client says, I want to give you a shareable Google Drive link and put the documents there. And this is the putting, like making people be persuaded about the balance. So in this way, it can be achieved, I believe, through some kind of professional and interdisciplinary training, because only this way people will understand the underlying risks, not only like really far away risk of being fined for 4% of the turnover. It's about seeing it's like really personal hygiene, like you know how to care. And it will be, of course, the GDPR makes you appoint a data protection officer, but I believe the law firms should kind of not put all the weight on one person, but work really close communication between HR departments, between clients, and also between independent contractors that the law firm works with. So it's about knowing your customer and knowing your colleague.
Thanks. That's probably quite a lot for an average law firm, but I think we have to move on. So Christina, please.